Okay, I don't see anyone in the waiting room, so perhaps we can get started. Good morning, everyone. I'll leave to Kayla to let me know if there's anything wrong with my audio. I'd like to start by acknowledging that the Law Foundation is located on the unceded and Indigenous lands of the Musqueam, Squamish, and Tsleil-Waututh people. And there are people joining here today from the diverse Indigenous territories all over the lands presently called British Columbia. And we're here to learn about how to engage with systems of colonial law in ways that assist our communities and undo some of the harms of those laws. So I will start by introducing the speakers. Myself, my name is DJ Larkin. I'm with the Law Foundation. You won't be hearing much from me today. I'm just here as a facilitator, so I'll be getting out of the way momentarily. You will be today working with Arnie Nagy, who is an Aboriginal advocate at the Prince Rupert Unemployment Action Centre. Arnie has been an advocate in many rights throughout his life, and he lives and works on the Tsimshian and ceded territory of the 9 allied tribes of the Lost Spalans and the Metlakatla. And you will be hearing from Dawn McConnell, who is a legal advocate with the Society for Equity, Inclusion, and Advocacy in Nanaimo, where she's been providing legal advocacy services in the Nanaimo and Ladysmith area since 1995, and she joins us from Stoney Territory. And Madison Powell, who is a legal advocate with TAPS, the Together Against Poverty Society, located on the Pungan and Wasanich territories in what's known as Victoria, British Columbia, where she's been an advocate since 2019. And prior to that, which comes from a background of social work. And Andrew Robb, a staff lawyer with the Disability Law Clinic. The law clinic is also located on the Squamish and Tsleil-Waututh lands. Rob is the staff lawyer and is presently the only staff lawyer at the only nonprofit community legal clinic in BC that specializes in disability rights law. And Allison Ward, who is a lawyer with the Community Advocate Support Line at the Community Legal Assistance Society. Many of you know Allison. She's been a lawyer with Castle since 2010, and prior to that has extensive experience working in poverty law through what is now known as Legal ABC. And she works at CLAS, which is also located on the Squamish and Tsleil-Waututh territories. Before we get started, there's a few little housekeeping things that I wanted to let you know about. One, because we're in a Zoom meeting, please mute yourself unless you're asking or answering a question. Please use the chat if you'd like to ask questions. The speakers have indicated that they're okay with people interrupting verbally as well if you have a question and need to get someone's attention, so don't be shy to do that, but otherwise please keep yourself muted. This session is being recorded, just so that people know. And the other piece of timekeeping is that I am told there is going to be a province-wide earthquake drill in less than an hour. So if you could turn your phones off or down or try to silence the volume, and just be aware that in about 50 minutes, everyone's phone might start screaming and alerting them to do an earthquake drill. It is just a drill. I don't have anything else. It is a jam-packed session, so I am going to turn it over to the panel now, and I'll be in the background to help with anything you need and to keep time moving because we have a lot of welfare case law to get through this morning.
Okay, thanks, DJ. I'm just going to step in for a minute before we get to our actual presenters. My role here is to sort of facilitate things as well and help organize the session. So we've selected 5 cases for you today, and I just want to review what we have in terms of materials. So we have 4 panelists presenting 5 cases, and we have a PowerPoint which briefly overlooks each case. But if you look in SCAD, you'll find that there are supporting documents for each case there. So as we pick cases, those of you who've been at this panel in years before know, we like to provide the submissions and decisions that underlay those cases so that you have them for reference and also for for future reference if you have issues like this that come up in your own practice, or of course, if you want to spend some more time reviewing the cases as we move along today. So they're all the materials in SCED are labeled with the presenter's name, so you should be able to locate them, I think, quite easily. The PowerPoint is also there. I'm going to jump right into cases. We have only 20 to 25 minutes per case. And we're going to be looking at 4 different ones. I think they all share a theme of really using some creative arguments and approaches, both at the tribunal, recon, and initial application to try and address real unfairness that has resulted in some of the issues that we're going to be looking at. So with that, I'm going to ask Andrew, who's our first presenter, to start, please.
All right, well, thank you very much, DJ and Allison. As you heard, my name's Andrew Robb. My pronouns are he and him. I am coming to you from my home in what is now called East Vancouver, on the unceded territories of Musqueam, Tsleil-Waututh, and Squamish peoples. Can we please go to the first slide for my presentation? Thank you. All right. I'm going to be talking about a case that went to the Employment and Assistance Appeal Tribunal in relation to an overpayment of CPP disability benefits. Can we go to the next slide, please? Thank you. So the specific legal issue that that I'm going to be considering is, can the ministry reimburse a person who is receiving disability assistance for an overpayment of CPP disability benefits, which the person received through no fault of their own after the ministry directed them, in fact, sort of forced them to apply for CPP disability benefits? And I will say that as part of my work at Disability Alliance BC, especially in support of our advocacy program, I've been involved in a number of cases in the last few months that have gone to the Employment and Assistance Appeal Tribunal, or the EAT, as I often call it, the EAAT. And most of those cases were about eligibility for supplements set out in Schedule C of the Employment and Assistance for Persons with Disabilities regulation, which probably most of you are familiar with. This case is not about that. This is a different kind of situation. And I thought it was interesting because I think it's a fairly unique issue. And I just want to say, before I get too much further into it, part of my objective in this presentation is to encourage more advocates to take cases to the tribunal. And I want to assure you that if you're considering doing that, that you should seek support, and you should feel welcome to seek support from others, whether it's your supervising lawyer or Allison or myself or a different law foundation lawyer. I think this can be very interesting work, and I think there is a chance to make a real difference to people. So I'll be going through my case in particular, but I'm going to be talking in sort of a more general way about the tribunal. And as I said, I just want to encourage everyone to consider taking their welfare cases to the tribunal for reasons that I will get into a little more later. Can we go to the next slide, please? Thank you. Okay, so this is a summary of facts in my case, and I'll read through it and then comment a little bit on it. In my case, the appellant had participated for many years. She received disability assistance. She participated for many years in the ministry's self-employment program, earning income through her small business. And so, as most of you probably know, that allows people who are on disability assistance to receive income through self-employment without it being deducted from their disability assistance benefits, as long as they follow certain rules and their total income from employment stays under a certain level. So she'd been receiving these disability assistance for many years. And then in 2019, the ministry told her that she had to apply for CPP disability benefits. And her CPP disability application was approved in 2020. And her payments, starting from when she started receiving CPP-D payments, those payments were deducted from her disability assistance payments. And that's standard ministry policy. That's, we're not trying to argue with that here. Shortly after she started to receive CPP disability benefits, the federal government, which administers the CPP program, the government decided that her self-employment income actually made her ineligible for further CPP disability payments. So those payments were stopped, and she was told that she should not, in fact, have received the last 2 payments that she did receive from CPP-D. So the total overpayment that was assessed was just a little bit under $2,000. So she contacted the ministry because when that money was paid to her, it was deducted from her disability assistance. And she thought, well, now that I have to pay it back, surely the ministry has some responsibility to pay it back to me. Well, the ministry said no. So I'm going to give a little more background than what's set out in the slide. As you probably know, it's common for the ministry to tell a disability assistance recipient that they must apply for CPP disability benefits. Disability assistance as well as income assistance are supposed to be income sources of last resort. In other words, you don't get them if you have other sources of income available, subject to some limited exceptions set out in the regulation. So she applies, so as it shows here, she applied for CPP-D, she was found eligible. What it doesn't say here is she was found eligible in July 2020, retroactive to September 2018. And so as a result of that, when she was approved retroactively by the federal government sent $21,000 to the provincial ministry. And that was for basically all the payments that she shouldn't have received from the ministry, because she should have been getting them from CPP-D instead. And starting when she got approved in July 2020, she would get about $1,000 a month from CPP-D, which was then deducted from her disability assistance. So her income stayed exactly the same. She didn't get any more or less than she was getting before, but the ministry was paying her less because some of it was coming from the federal government now. But by September 2020, just a couple months after she first started receiving CPP disability, her self-employment income exceeded $5,800, which, as you might know, is the cap that CPP-D allows people to earn before CPP-D decides that they are not, in fact, that they don't, in fact, fit into the qualifications for the CPP disability program. And she knew this. She knew before she got cut off by CPP disability that was coming. And she told the ministry that. She told them in December of 2020 that she would no longer get CPP disability benefits, but they still went ahead and deducted her October and November CPP payments from her disability assistance for December and January. And then it wasn't until April 2021, this year, that Service Canada notified her in writing that she owes them about $2,000 for the payments she should not have received in October and November. And that's when, as it shows here, she asked the ministry to pay the overpayment debt for her. And they said no. So can we go to the next slide, please? So we applied first, we asked for reconsideration. And the request for reconsideration included documents from the federal government showing when and why the federal government assessed the overpayment. And we argue that these documents show that the overpayment arose through no fault of her own. The request for reconsideration also cited a law called the Financial Administration Act. We argued that I'm going to call it the FAA. We argued that the FAA gave the ministry authority to reimburse the client for the CPP-D overpayment. The FAA is a rule that some of you might be familiar with because it also creates the estoppel rule that you might be aware of. And that's the rule that says the ministry can't collect, or generally can't collect, on an overpayment of income assistance or disability assistance if the overpayment arose through no fault of the recipient. There's a different section of that law that says in some cases the government can refund money that it received. And that section doesn't refer specifically to the Ministry of Social Development and Poverty Reduction or income assistance or disability assistance. It's just a general rule about how government works. And so I tried to say in the request for reconsideration, I tried to say that that law allowed the ministry to reimburse my client for the CPP-D overpayment. But it says in the last bullet point here, the reconsideration did not even address that argument. They did not talk about the FAA at all. They just said there's no authority for the minister to reimburse CPP-D overpayments in any circumstances. You know, they mostly just said, we followed the rules, we did what the policy says. This is an unfortunate situation, but we can't help with the overpayment. That's basically the message that we got from the ministry at reconsideration. Can we go to the next slide, please? Thank you. So we went to the tribunal, the EAAT tribunal. And I will step back here and say, when we started this appeal, I did not think that this case was a winner. I agreed to help the client because I was already working with her on a different matter, totally unrelated to this. And she was extremely upset and emotional about how the ministry had treated her. But all the time I was working with her, I was trying to manage her expectations. I was telling her, you know, there's no harm in doing the appeal, but this is a long shot at best. I understand that this situation where CPP-D payments get deducted from disability assistance and then CPP-D assesses an overpayment and the client effectively has to pay it twice, right? Once when it's deducted from their disability assistance and then again when they pay it back to the federal government. I understand this happens somewhat regularly, I don't know, occasionally in any event. And generally the ministry takes a hard line about it. So I wasn't really expecting a different outcome here, but I thought, like I said, no harm in trying. And I made about the same argument at the tribunal that I did at reconsideration, relying on that part of the FAA, the Financial Administration Act, that says the government can refund money in some circumstances. And the tribunal didn't buy that at all. They weren't having any of it. But they went out on their own and found a different section of that law. As it says here in the slide, they cited section 6 sub 3. And I had not mentioned that at all in my submissions. That was something the tribunal went out and found on their own after I sort of pointed them at this law, but I was pointing them at a different part of it. But as it says here, they found that this section 6 sub 3 of the FAA says that the ministry is responsible, and I'm quoting from the EAAT decision now. It says the ministry is responsible for the administration of its financial affairs under the general direction of the Ministry of Finance and Treasury Board, which are government agencies, as you know, that control government money. Therefore, regarding allowances and supplements, the ministry is expected to establish systems and rules regarding the collection of contributions from third parties and such matters as the accounting for and payment of disability assistance, including the establishment and application of processes to ensure that earned and unearned income are properly recorded and accounted for in establishing the amount that a client receives in any given month. Crucially, they said, when errors are made, they should be corrected. A little later, the decision went on to say, the panel notes, that is the panel of the tribunal, notes that the situation in which the appellant finds herself is exceedingly unfortunate and that the ministry's practice in these circumstances is procedurally unfair. Can we go to the next slide, please? And this slide says sort of what the conclusion was that the tribunal came to. It says the panel finds that all the evidence shows that the appellant did not ultimately receive unearned income in the form of CPP disability benefits in the months of October and November 2020. Furthermore, the panel notes that there are clear legislative requirements to apply the legislation fairly and to remedy the situation when errors are made. In this case, to retroactively increase the appellant's disability assistance for the months of December 2020 and January 2021 to ensure she receives the disability assistance to which she was entitled, and so that she is made whole and has the funds necessary to settle her account with Service Canada. I think that is a great quote, to retroactively increase her disability assistance so that she is made whole. I think that opens a door, and I think that can be used as a precedent in other cases, not just for exactly this scenario, but potentially other situations where a person receives overpayments from a different government benefit scheme other than the ministry. Can we go to the next slide, please? All right, what was challenging about this case is, first of all, I'm not aware, and that doesn't mean it hasn't happened, just means I'm not aware of any previous cases where the tribunal told the ministry to reimburse a person for amounts that were previously deducted from their disability assistance payments. And I will go beyond that and I will say, honestly, I'm not sure this decision is correct. The EAT's decision. I mean, obviously I'm happy with it and my client's very happy with it, but I think, if I was a lawyer on the other side, I'd be looking at this and I'd be saying, I can make some good arguments against this. And for a while, I thought the ministry was going to try to challenge it by way of judicial review. But I heard from my client just last week, and she told me that she spoke to a representative of the ministry who told her that they were going to pay her the money. They were just going to do what the tribunal told them to do. So that's reassuring. As it says here, one of the other things challenging about the case is there's no authority, at least I don't believe there's any authority in the normal rules, that is the Employment Assistance Act, the Employment and Assistance for Persons with Disabilities Act, and the regulations. I don't think it says anywhere in there that the ministry can reimburse a person in this circumstance. So it was challenging to try to convince the ministry and then later the tribunal to go beyond those rules, to look at a different law that applies, and that's not what they're used to doing. The other thing that made it challenging, as I said before, the client was emotional and took the ministry's decision very, very personally. And I was, of course, I was trying to empathize and support her. But honestly, I mean, everyone has different strengths. I am not great at dealing with emotion. So she got a little weepy at the tribunal hearing, only a little. She was still answering questions, but she had to pause and collect herself. And to me, it was a challenge in some way because, just as a person, I'm not always as good as I should be at dealing with emotion. But it was clear to me that I'm sort of switching to the upside of that. It was clear to me that the panel members noticed that she was getting a little weepy. And it was clear to me that it made them more sympathetic to her. So one of the things that reinforced for me, and this is a fine balance to achieve, obviously, but a little well-timed weeping can sometimes be useful in a situation like this. I'm not sure how you approach that with your client, but it's one thing I learned from this case. Can we go to the next slide, please? The other things I learned from this case, well, when a person has to pay back an overpayment from a government benefit program, such as CPP disability, and the overpaid amount has already been deducted from their disability assistance or potentially from their income assistance. I don't know for sure how it would work in that case, but I think possibly the rule could apply there as well. It's possible for the ministry to reimburse the person. I don't know if the ministry is going to admit that to you, but we have here a situation where the tribunal told them to do that, and apparently they are going to do it. So it is at least possible. And then I also want to say, in some cases where a person is facing an unfair situation through no fault of their own, the tribunal will look for a way to help them, even if it means looking past the normal rules. And so I'm coming to the end of my presentation, but I just want to do a little brief rant about the tribunal and about why I think advocates should be interested in going there more often. I used to do similar work to this in my old job, which was in Lethbridge in southwestern Alberta. And all the decision makers that I was dealing with there were like fairly conservative, not highly diverse people. And they didn't usually go for my interesting ideas about how social assistance should work. And one thing this case made me realize is I think there is a big difference with the EAT tribunal here in BC. A lot of the EAT panel members are retired government workers, like people from Victoria. And I think a lot of them are old hippies who actually do have some sympathy for our clients. And if you can show them that something unfair has happened and give them some kind of legal basis to fix the problem, even if the legal basis is maybe a little thin, often they are going to try and find a way to help. And I realize, of course, that not all EAT decision makers are like that, but some of them are. In fact, my experience so far is a lot of them are. And so I think that's a good enough reason for everyone to consider doing more appeals to the tribunal. No matter how half-baked your case might be, generally you have nothing to lose by trying to go to the tribunal. And sometimes it turns out you get a really good outcome, even when you might not be expecting it. I will also say the tribunal is, I find, quite user-friendly. Everyone is always very nice to me. It's pretty non-adversarial. I have to acknowledge my privilege, and I know that that might not be the case for everyone. But I would encourage you to consider going to the tribunal, get a taste for it, and see how it goes for you. And I'll just conclude by saying I'm always happy to talk about welfare cases. If you're considering an appeal to the tribunal, this is a subject that interests me. I know that you're going to get my contact information up at the end of the presentation, and many of you might already have it. Please feel free to contact me anytime. Interesting work. I think there's more of it that should be done. I'm happy to talk about it anytime. Thank you very much for listening to my presentation.
Thank you, Andrew. And I'll just pause there to see if anyone has any questions or any comments before we move on to Dawn's presentation. Is there anyone who has any questions with this?
There was one comment and question in the chat about judicial review. And I know that this was a fairly recent case, Andrew, so we're still within the period for judicial review. The 60 days haven't passed yet. Has the client actually got their money yet? Do you know?
Last I heard, she had not received it, but they told her it was coming. I mean, I see the question in the chat is, is there, I agree with Dawn, who is saying that maybe you can go to JR based on the fact that they relied on a law that nobody brought up with them and nobody made submissions on at the hearing. I think that would be the basis for to go to JR. And, if I had lost this case, maybe I'd be looking at it from that basis. But so far, knock wood, it looks like the ministry is not going to challenge the decision.
And there's a comment in the chat that at the Advocates Conference a couple of years ago, that the tribunal sides with the ministry 88% of the time. Is that still the statistic? Yeah, I looked at the annual report for the tribunal for last fiscal year. It's 2020-21. It looks now that the success rate for appellants is about 17%. So it is up. I think that, I don't know, Becky, that was quite the right number. I think that it used to be hovering around the 6 to 7% success rate, very, very, very low. But there have been some changes in the tribunal since then, one of which, of course, is the rule regarding new evidence that changed last year, and I think has made a difference in some cases. There's also been a change in the chair of the tribunal. But I think it remains to be seen, because we know that both the reconsideration level and the tribunal level during the pandemic, volume of appeals has been about half of what it was previously. So I don't know if that 17% statistic from last fiscal year kind of is just a COVID blip, or if it's going to reflect a more continued trend. Madison's saying that last month, the chair of the tribunal provided updated statistics to TAPS, 30% rescind rate, success rate for PWD designation, 19% rescind rate for non-PWD. So that's actually higher than what that annual report reflected.
I know that in one of our meetings with the chair, we had asked them if they would consider breaking down those statistics to show what the rescind rate was. In other words, what's the success rate, particularly when the individual has an advocate working for them. I think that would be really interesting information to know, what kind of impact we as advocates have on success rates at this tribunal. I would say I've been doing this for about a year now, and I have a pretty good success rate at the tribunal. And my experience is when an advocate takes a case pretty seriously and goes to the tribunal, obviously it's not going to go your way every time, but from my observation, when a person has an advocate, they stand a real good chance.
So being mindful of the time, I see that there's one comment in there from Tish, and I wonder if that might be the last comment. It has to do with concern around the standard for the ministry's decision-making, and being concerned with whether the ministry acted reasonably rather than whether their decision was correct in law. And I wonder if either of you have any comments on that, and then maybe we could go on to John's presentation.
My comment would be, I agree with Tish. I think that is a concern. I don't like that the law is drafted that way. I'm not confident it's going to change anytime soon. But I think the positive that I would take from that when it says that the tribunal can determine whether the ministry acted reasonably, that gives the tribunal a lot of discretion. There's a lot of room for the tribunal to maneuver within that reasonableness standard. Like I said before, if they want to help your client, if you can show them that it's a situation of great injustice, in a lot of cases, they're going to find a way to help. Not always. And certainly if they want to find a way to make a decision against your client, there's usually a way for them to do that too. So I agree it's a concern, but I think it's something that, we're probably going to have to live with anyway. And there is a way, or at least there is some reasonable path to try to get around that concerning reasonableness standard.
Thank you, Andrew. So I think we're going to move on to Dawn's presentation now.
Thank you very much. Can everyone hear me? Thank you. I've already been introduced, so really I didn't need this screen. If you want to, thank you. My case is about accommodation for the client, but it came to me as a non-compliance issue. And I've placed the Ministry Employment and Assistance Act for Persons with Disabilities, because my client is a person with disabilities. And the Act sections used were 1, 1.1, 3, and 10. Next slide, please. So the summary of facts are, my client is married, was an immigrant to Canada, and has English as a second language. She came from a country where there's a severe bias against gender and religious faith-based practices. She left her country, in fact, on the basis of, she was working for a studio in her country of origin, And her employer was harassed pretty much on a weekly basis for the fact that this individual had hired her because they were aware of her religion and of the shop owner's religion. So because of that, because these political or these government officials kept coming into the store on a really regular basis, much more than just once a week, it was 2 and 3 times a week, she realized she needed to leave the country. So she did. She came to Canada. She started a job here and was successful. Unfortunately, she came to Canada with some baggage because of her country of origin. And it came to the point where she could no longer work constructively at her job. COVID stepped in and basically that dried up all of her income source. So she applied for income assistance and then was successful in getting PWD designation. At the time of application though, and what I haven't placed in here, is that she was married, but her husband was not in the country. Her spouse was not in the country. He was away. And so she applied as a single person and the ministry was not aware. They weren't aware that she actually was married. So she applied under her name, which she kept in the marriage, even though she was married. The spouse finally returned home when there was a lift of the travel ban, and the spouse could not find work due to COVID. So she requested that he be placed on her file. Then a file review came. And next screen, please. The ministry was very, very focused on the fact that they believed that this was a fraud case. They actually write it in the reconsideration request. You'll see it in the scheduled package. The fraud came up 1 or 2 times in that package because they believed that she applied inappropriately as a single person, even though she was married. This just led me to believe there's a whole bunch of mistakes made on both parts and a lot of assumptions made on both parts. The ministry kept insisting that the client bring forward more and more documentation, and it changed up every month. Every month it changed, or actually more than every month. It was pretty regularly. This whole thing culminated in a face-to-face meeting with the ministry worker, with both the husband and the wife in the office. And they had this, I don't know if anyone's ever seen one of those review forms or re-registration forms and all the information that's on it. But there were some inaccuracies or some information that was in error submitted on that form. And the client asked that it be changed because one specific piece of information is that she had a renter boarder. She didn't. And they said that she was making $1,500 per month on that room and board situation. What it was, in fact, this was a family member who looked after her when she was a child, because in the country of origin, there is no social welfare process. There is for people who are from another income or another religious faith that may get the social programs. In this country of origin, the individual would have to have worked 30 years and paid into a social welfare system. And because of her faith, she probably would never have received it. So the client asked that certain changes would be made to the reapplication form. They weren't. But because she was led to believe that they would be changed, corrected, her and her husband both signed the form. So the ministry, because they said that she has not claimed the $1,500 room and board for her brother and his wife, they cut her off effective June 2021 for benefits. She requested a reconsideration of the denial of benefits. Next screen. When she came to my office, she was already past the reconsideration date. And I realized very quickly that she did not comprehend, other than she wasn't getting any money, she did not comprehend the contents of this reconsideration request, other than she wasn't going to get any money. And so she just sort of threw the papers at me. And this is a very smart woman. She's a very smart woman. She owned and operated her own business in Canada. She has mad skills, but the paperwork was a bit daunting to her, and she could not comprehend because of the heightened anxiety that she experienced through this whole process. Government, in her eyes, were very fear-making, and she basically lost control and could not read this. So I ran through it really quickly. I asked her questions, and that's when I found that there was a language barrier here, because she would answer questions to me that I'm going, why are you answering me this in this way? So I would have to change how I spoke to her and asked her the questions in a way that she could comprehend what I was asking for. Many times I would ask her questions and she would just nod her head and say, yes, oh yes, that's exactly what happened. But then as I'm going through the questions in the reconsideration request, and please take a look at it if you can, because it's very interesting how the ministry worked this whole thing. She would answer me incorrectly, and I knew she was, because she didn't understand. So because this reconsideration request was late, and it was even too late to ask for an extension, I asked the ministry to see whether or not I could just reapply. And the worker said, yeah, let's reapply. When she got to a certain part of the application process, the ministry worker online, or on the phone, I should say, said, no, I've just been advised that this person cannot reapply for income assistance, even though the request for reconsideration timeline has been exhausted. So the request was refused. I put in an immediate request for an extension of this reconsideration. And I just sort of put it up to that during COVID, the reconsideration timelines were a little more fluid. So I went, okay, fine, I'll do the appeal. I wrote up the appeal argument and submitted it to the ministry within the timelines. And this, when you read it, I'm somewhat embarrassed, but please read my submission appeal document. A lot of errors. I was amazed. Within 1 week, the appeal was accepted. And this is what I argued. I took the ministry value mission statements and threw them at the ministry, saying how this client had not been listened to appropriately. No interpreter had been suggested, or even, it didn't come across, it wasn't offered, never mind suggested. And that based on the fact that she comes from a country where government is very scary, to be feared, and that she had mental health issues, more than one, that they had a duty to accommodate her mental health impairments, along with English as a second language and being an immigrant to Canada. The ministry accepted the argument and said that from this point forward, they would have an interpreter for communication, either on the phone or in person, because they recognized in the argument that there were vast barriers to the flow of communication between the client and the ministry. Next step, Next slide, please. What was challenging, I think I already went over. The client's accent was very challenging over the phone and in person. English as a second language was also challenging, as many times questions had to be restated or changed to allow for clarity and understanding on both parts. Documentation, like I said, very problematic for the client. I think that had a lot to do with the mental health issues that she was living with. And so comprehension of any ministry documentation was very limited. It was more necessary than ever before to have this client in the office. Normally, once I see the client 1 or 2 times, I do everything over the phone or through email. And in this case, I had to have her in about 6 times because our phone connection was so difficult. I kept asking her to repeat stuff. It was so frustrating for her. It was just easier for her to come into the office, and I was able to put things down in a very, very easy to, hopefully for her part, easy to digest. And as I said, PTSD and anxiety impacted how the client responded. The fear of perceived authority and the process outcome made answering questions very difficult. Not that she saw me as an authority necessarily, just the process was very, very difficult for her. Next slide. Takeaway, or things that I've learned over the years. Read all documentation. People write these RFRs and mistakes, oversights, biases occur. Listen to your coworker if you have one, if you're lucky enough. Mine advised me against taking the case because it was obvious that the client was lying or misrepresenting the case. But that only forced me to question the contents of this case even further. I really, really digested all the stuff that was in this document. Talk to your lawyer advisor. I did in this case and successfully argued to my advisor that the case could win on the basis of accommodation and reasonableness, and that the client, in fact, was not being non-compliant. And then lastly, listen to your gut. If things are not adding up, they're not making sense, look at the document again, talk to your client again, find info about other cultures, dive into the ministry legislation, and I should have put here the values and the mission statements, and definitely look in other directions to find out why the communication broke down. And that's it. So if there are any questions, I would love to answer them, or if there's any comments you want to make, please do. This is my first time on Zoom presenting, so I'm a little bit.
It went great, Dawn, and I see Allison unmuting herself because we do already have one question.
Yeah, there's a question in the chat, Dawn, asking what department of the ministry the client was dealing with. Was she dealing with an EAW and at the local level, or was it with PLMS?
Local.
Cool. And I know you're very modest about your submission, but there is a copy of it in SCED, and I thought you did a really effective job of contextualizing the client's situation, both in terms of raising the ministry's failure to consider accommodations for the client in different ways because of language and culture, and also providing social and cultural context for the client. I noticed you referred to supporting documents that you included with their submissions, and those supporting documents aren't on SCED, so maybe you could talk a little bit about what you provided to try and really make the ministry understand the situation the client was coming from.
Okay. I actually I did a Google search of social welfare programs in other countries. And I looked specifically for my client's country of origin. And what I found, that's where I found the information that I was talking about, that she could work and pay taxes or pay into the social welfare systems of her country of origin, but because of her faith, she would never be a recipient of those benefits. So in her culture, family takes in family. She was an orphan about the age of 16. And so her brother took her in and paid for her clothing, paid for her food, paid for everything until she found a job. But the job that she acquired in the country of origin was very low paying and basically just paid for her clothing. And so I dug a little deeper into the culture of social welfare in the country of origin, and there's very limited social welfare programs. If her family hadn't taken her in, she pretty much would have ended up becoming a sex trade worker or a subsistence, somebody who could not live very well in her country of origin. Does that answer the question? Does that answer what you were looking for, Allison?
So I just thought it was an interesting approach, like to take Andrew's point that at tribunal he found, that portraying the particular individual humanity of the client was very helpful. I think that even on recon, of course, it's written submissions, that is also very effective in raising accommodation issues. And I thought you did that particularly well.
Thank you. I think it was also really good to investigate the mission statement of the ministry, the values of the ministry, and I love throwing that at the recons every so often if it fits really, really well. And in this case, I believed it did.
Mm-hmm. Okay, just watching the chat. Do we have any other questions about Don's case? Oh, yes.
Very good one. Is that the?
Can you see it?
Yeah, I can address that one. That was part of the communication breakdown. The client had invited her brother, who had put her up and taken care of her financially for many years in the country of origin. And so when he came to Canada, this was part of the culture that she take her brother in now and not charge him any money for rent or for living in her home. And the ministry worker, I believe, and again, this is, I'm assuming, which is wrong, that it should be approximately $1,500 that he should be paying her for this 3-bedroom basement suite. They also tacked on, and like you can read in the reconsideration request, that they had children as well. Well, the brother's children were grown and gone. There's no way that she would charge her brother $1,500 a month. So I'm not really sure with that $1,500 per month the ministry put into the document, because she never stated in anywhere that her brother paid rent or room and board, or that his 4 children who are adult grown children that did not live there, it's only him and his wife in the basement. Shoot, now I've forgotten the other part of the question. I know she did say that she received gifts from her brother, and that sometimes he paid portions of bills that came to the house, like utilities or garbage. But that, in her mind, she only accepted that money, and it was under duress, because this is a very proud woman, a very incredible, proud woman. And she would only accept it if the lights were at risk of being turned off, and that she knew that her brother would be discomforted by not having the garbage picked up or the lights off. Those are the only reasons she accepted any money. And it states in the response from the ministry to the request for reconsideration that they understood that these were in fact gifts and not money that he gave her on a regular basis. And the $1,500 was never mentioned again in that whole thing.
And if I recall your submission correctly, you also provided copies of bank statements, I think, to show the absence of any
Absolutely.
$1,500 deposit.
Absolutely. One of the things that she kept trying to push me to submit to the ministry as well was her brother's household utilities bills, because two of her brothers lived in the same community. And I said, you don't need to submit that. There's no lawful reason for you to submit your brother's utility bills along with yours. Again, showing up her not understanding what the ministry is expecting. She just wanted to throw everything at them. She wanted to give the ministry her brother's bank information. And I said, no, that's not what they're requesting. But her fear was so great that she was trying to overshare when it really wasn't necessary.
Mm-hmm.
Yeah.
And just to answer that question a little bit further, it was a Section 10 cutoff for non-compliance, not providing information and verification. It wasn't a cutoff for having specifically alleged income in excess.
That's right.
So that issue was to do with, had she provided adequate information about her situation. And so it sounds like that was addressed very fulsomely.
Thank you, Jan. That was a nice comment.
Yeah, thank you, Dawn and Allison. And yes, there's a lovely comment in there noting that you really got to know your client's situation, and it sounds like that really made you a difference in the outcome and your ability to advocate in the situation. And so I'm looking at the time, and we are right on schedule, so no need to rush, but we are doing fantastically, and we will move on to Arnie next.
Well, if you want, I can really screw up that schedule in a hurry.
Thanks for the offer.
Anyways, my name's Arnie Nagy. My Haida name is Talatska Chin Kilju, which translates into strong salmon voice. I'm a member of the Sajagal clan of the Haida Nations, and I'd like to recognize the fact that I live and work on the unceded Tsimshian territories of the 9 allied tribes of Lakwalams and Metlakatla. I'll give this overview of facts on a claim for income assistance that I applied for a client that really turned into a year-long effort to get my client his income assistance application approved. It took 5 separate applications for income assistance to finally get to where we found a resolution that my client could get on income assistance. My client lived with his mother while she was sick, and he looked after her until she passed away. The mother owned the home where they lived and would not allow any of her kids to apply for income assistance while they lived with her because of the social stigma that was attached, as she was a very well-known woman in the community. When she passed, the client had no source of income, and he needed to apply for income assistance. The will named my client as the sole executor of her will. As the executor, he was responsible for his mother's estate, including the house he was living in, as well as other rental home that his mother owned and was renting out. The client's brother, who was also on income assistance following the death of his mother, lived with the client in the mom's house, or the mother's former home, now owned by her estate. The client and his brother paid rent to the estate of $375 per month each, and the tenants in the other rental unit owned by the estate also paid rent. Can we go to the next slide, please? So my client would take all of the rental monies from him, his brother, and the other tenant and deposit the rent monies into his personal bank account so he could access it if needed for emergency repairs on the rental unit or the house that he was staying on, and to pay for other bills such as property taxes, utilities, or if needed, contractors to do repairs. If the rental monies were put into his mother's account, it would be frozen by the bank and he could not access any funds to maintain the properties. So and also another issue was, as the executor, my client would have to sign the ministry's intent to rent for the shelter allowance that he was applying for. The issue started is when he applied for income assistance, the monies in his bank account totaled just over $9,000, which put him over the asset exemption level of $5,000 at the time. Today it's $10,000. Even even after we explained to the ministry that this over amount of on the exempt portion was because he needed that money in there to have access to protect the viability of both rental properties in case something happened. So what the client did is he took $5,000 out of his personal bank account and deposited it into his brother's account. So he was under the maximum amount he was allowed. So we did another application, and when the client provided the bank statements to the ministry, they saw the $5,000 transfer to his brother's bank account, and he was denied income assistance again, based on the fact this money was from his personal bank account, and the ministry thought he was disposing of assets when in fact the money was an estate asset. Meanwhile, the rent from both houses were still being deposited into the client's bank account again, creating the same issue of having money over the $5,000 limit that was allowed at that time. The mother's will, and still hasn't, the mother's will has not been probated as issues arose with the surviving sibling, the sister, over the contents of the will. And until this situation of receiving the estate income could be resolved, my client could not get income assistance. So before we go to the next slide, we tried many different solutions, working with Ian Harrower from the ministry and getting stuff going with the policy department of the ministry to try and figure out a solution. I can tell you one thing that I learned during this whole year was, if you're going to wait for the policy department to come up with a solution, you're going to wait an awful long time. So it's actually best for you to try and come to a solution on your own and present it for approval. Can we go to the next slide, please? So finding a solution proved to be a very challenging experience, as no one in the ministry or the policy department had seen this issue before. Working with Ian, the service quality manager, over several months, we proposed several different options to try and solve this issue. There was a lot of confusion in the policy department, and getting to a resolution was difficult. We offered several solutions that the ministry rejected, but they never provided us with any possible solutions. One, we could open a separate bank account in the client's name for the rent money to be deposited. It would be for estate purpose only, and this was denied as the assets would still show as being in the client's name. Two, we could set up an account in the client's name where two people would have to sign the check to pay estate bills. This was also declined, as they said there was no guarantee it would be used for estate purposes only. The third, we offered to provide bank statements on an ongoing basis to show the account was used only for estate purposes, but this was also rejected by the ministry and the policy department. So following this, I decided, well, we got to start thinking of how I'm going to deal with this, because as a former union organizer, I don't like to take no for an answer from the boss or from the ministry on something like this. So I made some phone calls, one to a notary republic who's a friend of mine here in Prince Rupert, discussed the situation with her, and then went down to the local credit union where I know the bank manager. We're old high school friends and been in contact for quite well up until now, and would set up a meeting and went in and talked to her about this situation, and we bumped heads for about 45 minutes, and this is a solution that we were able to come up with. Can you, next slide, please? After many months of trying, we finally found a solution. As I said, I approached a friend who manages a local credit union, and this is the proposal that we came up, that the ministry and the policy department eventually accepted. An account would be set up in the client's name, but with the specific account designation of estate purposes only. The credit union would monitor that account for any unusual activity that did not fit for the estate purposes only expenses. The client would swear a declaration with the local notary public listing the bank account information and clearly stating that this account was only for the mother's estate and was being administered by her executor, my client, to meet the estate expenses. And a sworn copy of the declaration would be filed with the bank and kept on the accounts file until the estate had been probated. A copy was also given to the ministry, but unfortunately, I think somebody didn't put it into his file, because when I talked to him about this, we couldn't find it. So I've got a copy here that I'll have to forward it to him. If we go to the next slide, we can see what the draft was. Hopefully you can see it all, but I had to load this on from a PDF, so it's kind of stretched and stuff, and I've never set up a PowerPoint presentation. So, but this was a declaration that we had done. So in the matter of an application, the name of the client for income assistance, province to which the person's name and everything and his address, solemnly swear that he is the applicant in the matter. As such, personal knowledge of the facts here, however they say all of those legal terms, which facts I believe to be true and correct, so that he names that he is the executor of his mother's name and the deceased in the estate. Secondly, that on behalf of the state, he has opened account, and there we put the account number, afterwards known as the account, at the Northern Savings Credit Union branch in Prince Rupert, for express purpose of receiving the estate revenue, providing estate maintenance and paying the estate expenses. And that he has no personal interest in the account, and nor does he personally receive any financial benefits from the account. And that this declaration in support of my application for income assistance. So, and then we had it notarized by the local notary here. So this is how we came to how we got him on to the assistance. So after we had all this done, we submitted the 5th application for his income assistance on July 7th, 2020. On July 10th, I called the ministry to see his caseworker to see how the application going. And on July 15th, we finally got word that the policy department had accepted this solution and that the client was informed his claim was approved. So it was exactly 1 year and 4 days after we started this process that we finally were able to find a solution to get my client onto income assistance. there's still a few things that we have to work on in regards to the estate and his brother, who we are trying to get on PWD. So when the will is probated, he doesn't run into problems with the other family house coming into his name. But first thing is PWD, and the other major thing is that we got this issue settled. I talked to Ian to see if the policy department has done any memos or internal memos in regards to this type of a situation, and there is nothing. So I talked with Paul, and I know Paul's going to raise it with the Moving Forward Committee. I realize that this is once in a lifetime kind of a situation that nobody favors, but I think that this type of a scenario when it comes to estates and stuff could also be used to help other clients who may find themselves in this situation and are in requirement of income assistance to get something done. It was an interesting learning experience, but I think, you know, some of the guidance from Paul, but the contacts that I have made in the community, we were able to work with different offices of like the Northern Republic, the bank, Ian, and others to try and to finally come up with a solution that was acceptable. And it was a big relief for my client. So now he can move on and start trying to deal with the estate issues instead of trying to figure out how he's going to survive. He was very fortunate that his brother was on income assistance, and the monies that his brother received were helping to provide the fooding and stuff. And he had a little bit of a bank account that he used and lived very sparingly until we got him on income assistance. And the fact that it says the hydro bills and everything should just come out of the estate, because this isn't your issue because you couldn't get on income assistance. Use that money to cover it, because you have to legally make sure that the properties are heated and maintained so that they don't fall in bad state. But other than that, yeah, a year and a bit. And as I say, if you run into a situation and want the policy department to find the solution, I wouldn't wait. I would do what you have to do and try and find some idea or some ways on how you can come to a solution yourself that they will accept. But
that's great, Arnie. There are a few questions for you in the chat, so I'm just going to have a look through them here. So first, there's a note. Someone saying that once a person starts acting as executor, it can be difficult to withdraw. Just the idea that, oh, well, if the problem was he was the executor, would one option be just to stop being the executor and kind of get rid of the problem that way? But yes, it can be difficult to withdraw as executor once you started acting. And my understanding of this family situation was he wanted to continue as the executor as well. There's a question, did the ministry issue denial decisions that mentioned the estate? So of those 5 applications he did, of the 4 denials, did the denials mention the estate?
They never mentioned the houses or anything, but what they did was the main problem that developed was the assets from the rent that was being paid into his bank account that put him over the limit, and they would not recognize the fact that that wasn't his money, but he needed that money in order to maintain the well-being of both houses.
Mm-hmm. Then the second part of that question is, do you think the asset policy has changed since? And I guess you kind of answered that already, saying that there's no formal policy dealing with executors and estates yet, but there's going to be some follow-up on that, right?
Yeah, he's going to bring that issue up and see if we can't get something in place that will, within the policy department that deals with estates.
Mm-hmm. And then someone's commenting that they think it's likely a more common situation than we realize, because clients who are denied for assistance don't always come forward. And I think that's really true. in terms of the asset policy, I will say that I think this is really similar to another situation I know some of the advocates in the room are familiar with, which is where a client may have assets in their name. For example, if their parents, for estate planning purposes, say the client's on PWD and the mom in her will puts the client on the name of their house so that down the road the client will inherit it. And in that case, there can be an argument that the client, it's not really the client's asset. It's not their house now, it's planned for the future. Legally, that translates into an argument that they don't have a beneficial interest in the asset, and therefore it's not their asset for the ministry's purposes. So I think that's similar to the situation here. And the way the ministry accepted a solution is similar as well. So in an argument where you want to establish that a client doesn't have a beneficial interest in an asset, let's say the mom's house, it requires evidence of the intention of the parties at the time that they set up that arrangement. So what did the mom intend to happen when she set up her estate planning in that way? What did the client intend? And there is a BC Supreme Court case that says that in a situation where you're trying to establish that you don't have a beneficial interest in an asset, there needs to be sworn declarations. So statutory declarations of the intentions of the party, which is really what this sworn declaration that your client did with the notary public almost amounts to. So I would think it's very similar. And because we know that situation exists with beneficial asset arguments, I'm quite disappointed that the ministry didn't come forward with this kind of proposal to you somewhat earlier, right? Not that they forwarded it, because it was you that came up with the solution. You've got lots of kudos here. Well done, and thank you for sharing. Thank you for the advice. Do you think you could drop the link to the BC Supreme Court case in the chat? Yes, I certainly can. I will do that. I think as we move through the next presentation,
Yes.
my eye on the time.
We are just cruising right along, and we are right on time for Madison's presentation of 2 cases. We've got plenty of time left, but we're just barely squeaking through. So maybe we'll move on. And Allison, if you do find that link to the case, that would be really helpful.
Sure.
Great, thank you. So yeah, I have 2 cases that I was going to present today. We'll see if I have time for the second one. The one that we've chosen to start with is a crisis supplement reconsideration. And we'll start the next slide, thank you. So summary of the legal issue. So this started out as a service request for crisis supplement for shelter. That one was denied. So the legal issue is surrounded by the eligibility criteria for crisis supplement, of course. So just to remind folks, the 3 main criteria are that you have to be facing an unexpected expense. Going without the supplement has to leave the client at imminent risk to their physical health or removal of a child. And they have to have no other resources to cover the expense. In the denial for the service request for the crisis supplement, they mention the policy provision that crisis supplements can't be issued for an ongoing situation, and that a crisis supplement, or in this part as part of the regulations where it says a crisis supplement may be provided only for the calendar month in which the application or request for the supplement is made. So in this presentation, we dive into some legal analysis of those 2 things as well. Next slide, please. So a bit of a background on the case. This one, I do have the file uploaded onto SCED. So this one is under Madison's crisis supplement file. So there you'll find my submission with a more fleshed out background of the situation and my submissions, and then the decision that came of it. But just to summarize, so for this file, this client was a income assistance client that eventually, throughout the course of the case, did become approved for PWD. What happened was they were living in a 2-bedroom suite. And in June 2020, the client's roommate left unexpectedly, just disappeared. There was like a full missing persons report and everything like that. Disappeared, left all their belongings behind without any notice. But during that time, you guys might remember there was a moratorium on evictions because of the COVID-19 pandemic. People weren't able to evict people during that time. So that lasted from, well, it was, I think, earlier than June, but for the relevance of my client's case, that was happening from June to August. So my client was essentially paying their half of the rent, but was unable to cover the roommate's portion of the rent for a few months. They weren't sure what was going to happen because of the moratorium on evictions. They knew they couldn't be evicted at the time, but they also were having trouble finding a new roommate in the meantime. For one thing, their roommate just disappeared. They weren't sure if they were coming back or what. But also, I include some submissions about it being difficult for my client to find another roommate during that time because of COVID-19. Difficult to show your apartment, have lots of people coming into the apartment. That was something that was sort of advised against by the government regulations. So essentially, this client went from June until the time of our request without another roommate. So during that time, they had accrued, I think, about or some pretty significant rental arrears. So at the end of August 2020, the moratorium on evictions was lifted, meaning landlords could evict people for non-payment of rent. There were some stipulations on that. There were, I believe, landlords had to offer repayment agreements for some of the arrears. However, that was only for arrears that were accrued from over the summer when the moratorium was on. So that didn't apply to any arrears from September or October, November, or ongoing. So at that time, she had arrears that were due immediately from September, non-payment of rent. And then she had some arrears from the summer that she could enter into a repayment agreement for. So in September 2020, that was the first time that she was sort of legitimately facing eviction because the moratorium had ended. So at that time, she visited us at TAPS and asked for some help with a crisis supplement request. So at that time, I helped her with a service request for a crisis supplement for shelter. We explained, our points about how we thought she met the eligibility. We said that that her roommate had left unexpectedly. So that was what was to help us meet the unexpected criterion. We explained that since she was just on income assistance, she had no other resources to pay for the roommate's other half of the rent. And we also mentioned in quite a few of our crisis supplement requests and recons that income assistance and PWD are both benefits of last resort. So to access those benefits, you have to prove to the ministry that you've exhausted pretty much all other resources available to you. So we argued that. And then for the imminent risk to her physical health would be, of course, the risk of homelessness. So we explained that especially somebody such as my client who has disabilities, even though they weren't approved for PWD at the time of that request, we still mentioned their disabilities and how homelessness poses an even more severe risk to them because of those disabilities, not to mention the COVID-19 pandemic and the additional risks to homelessness that follow that. So yes, this crisis supplement request was originally denied. And next slide, please. So the steps in this case, we brought it to reconsideration, and yeah, spoiler, we were successful at recon. So in the reconsideration, essentially what we chose to do was first just reiterate and expand upon our arguments about how she met those 3 eligibility criteria. So again, the unexpected, no other resources, and imminent risk criteria. But this time we added to the unexpected, we added actually an additional unexpected factor that we think made her eligible for the crisis supplement. So yeah, we said that yes, the roommate did leave unexpectedly, but also at the end of August, the moratorium was lifted somewhat unexpectedly. I suppose, you know, it could have been conceived of that the moratorium was going to be lifted at some point, but when and under what, like the details of the moratorium were yet to be known. So we made an additional argument for another unexpected circumstance that happened there. And I guess skipping ahead a little bit, part of the reason why we added that that factor in the reconsideration is because the ministry cited in their denial these 2 factors here. First of all, they cited the policy that says that a crisis supplement cannot be issued for an ongoing situation. And then they also cited, like I said in an earlier slide, that they cited the section 57 of the regs here. So again, I can read it. A crisis supplement may be provided only for the calendar month in which the application or request for the supplement is made. So what they expanded upon that regulation, and the way that they applied it is they said, well, since the roommate left in June, we can't issue a crisis supplement in September. That's the way they tried to apply that piece of the regulation. So that was part of the reason why we added to the unexpected criterion by saying that the moratorium was lifted to apply to be in September. And so that is essentially when the risk became like immediately imminent. And that was the details of the moratorium being lifted were unexpected. Like the client wasn't sure if they would have to pay their arrears. That details of that weren't released until September. So because they cited that regulation, that's part of why we expanded the unexpected circumstances. But additionally, as you'll see, if you look through my submission, is that we found that was actually just, we thought, an inaccurate application of that regulation there. So we say here that, so the ministry tried to say that because the crisis happened in June and the request wasn't made until September, that that made her ineligible because of this regulation. But if you kind of look closer at it, like it sort of, you know, sometimes the way that these things are worded, they need kind of like a close look. I'm sure a lot of the lawyers in the room are fairly trained on the process of that. But I don't know, for me personally, as an advocate without a super robust law background, sometimes I would maybe have the tendency to read this and think, oh, okay, well, the ministry, yeah, maybe they're right about that. But kind of upon a closer look, I realized that this regulation is actually just saying that a crisis supplement can only be issued in the calendar month that it's requested. It doesn't actually specify that the crisis itself can't happen in an earlier month than you're requesting the application or requesting the supplement for. So essentially, we refuted that denial reason, saying that that was a inaccurate analysis of that regulation and application of it. But I guess moreover, since that was one of their denial reasons, then we did say that, well, there was actually another unexpected event, which is the moratorium being lifted. So we essentially said that there was another unexpected event that happened in September itself, and that was the same month that we made the application, and that's the month that we're requesting the supplement for. So we kind of took a bit of like an approach of like throw everything at the wall and see what sticks for this submission. And then for the policy point about it being an ongoing situation, we simply just argued that the client had only made this one crisis supplement request for this particular circumstance. So therefore, she's not requesting ongoing support for this situation. I suppose what they were getting at likely with this one is that the client still doesn't have a roommate to pay the other half of the rent. So we spoke to that a little bit as well, saying that, well, we just discussed, of course, the reasons why she wasn't able to find another roommate during the pandemic. But also we said that even going forward, if she did have to go a few more months without another roommate, she actually was approved for PWD before we submitted this recon. So that made it so that she has higher support rates that she could use to cover the other half of the rent going forward. Yeah, I believe those were the main arguments that we used in our submission. And it was approved. She was approved for up to the full maximum for her shelter rate that could be used towards her arrears. A couple other interesting things I thought about when I was doing this. I was just kind of trying to remember back to that time, but I'm not sure if any of you folks had experience with this, but during last summer, we tried to submit a few different crisis supplements for shelter. And we found that a lot of them were getting denied because the ministry would cite the moratorium on evictions as being a reason why maybe the request wouldn't have been imminent, because they weren't able to evict people during those few months. So even though they didn't, well, because this application wasn't made until September, but yeah, we found that this was kind of an interesting case that we were sort of balancing the timing of when to make the request. I guess I'm jumping the gun a little bit. Maybe we can move to the next slide. Yeah, so I found that was kind of a big takeaway, was when to time the request for the crisis supplement, sort of finding the sweet spot for when a crisis is imminent, but still can be considered unexpected. When we were discussing which cases to maybe include in this seminar, Allison and I talked a little bit about this because, yeah, I've noticed in my own practice, it's something that I've found challenging is when a client comes to you with a particular situation and you're trying to figure out whether there's strong merit or not. Sometimes it can be a bit difficult to know, whether it's an appropriate time to be making that request. I think this example came up in one of the previous sessions during this conference, but the example of, let's say, like you're requesting a crisis supplement to replace like a winter jacket, something like that. Of course, you might not be able to make that request in the summertime because the ministry may not see that need for your winter jacket as being imminent. But then it's not necessarily possible to wait until winter and then request the crisis supplement for the jacket, because then the ministry may not see it as unexpected. But I would say there's a little bit of, well, it depends on your circumstances, of course, but I would say that sometimes there's a little bit of room to push the boundaries in some of those criteria. Like, for example, even if this client, even if we hadn't been able to include that second unexpected factor, of the moratorium being lifted, I think I would still have taken on this case and just argued that even though the client's roommate left in June, I don't think it was necessarily true that that it would have been unexpected, even though she would have waited till September. Like if someone, yeah, I guess I just mean to say, yeah, it depends. You'd have to take a close look at the facts in the case and everything like that. But I think there's sometimes a little bit of wiggle room there to if you can try to prove that it's unexpected, because the ministry doesn't have a lot of boundaries on, what that means. Like, yeah, when something is expected versus unexpected. So depending on your capacity to take on cases, I would say that, yeah, maybe trying to take a little bit of a step back and kind of coming up with creative arguments for how you can meet that unexpected criterion. Other things to take away from this case. Yeah, knowing when to push back on adjudicators' interpretation of the legislation. I guess me last year, and this is when I took on this case, I would have had, I suppose, a year of experience in the project, but I wouldn't say that I was, feeling super confident about my analysis of the legislation, of course. Like this would have been a bit of a new circumstance for me at this time. So I remember first looking at the way the ministry had used that regulation, when it said that a crisis supplement may only be provided for the calendar month in which the application or request for the supplement is made. I remember looking at that and thinking, oh, shoot, okay, yeah, we might be hooped. But I believe it was through consultations with my supervisor and another senior advocate here that we took a little bit of a closer look at that and said, hey, wait, they're not applying that right. They're trying to say that means the crisis has to occur in the same month that you made the request. But upon a closer look, that's not what that provision is saying. It's just saying that the crisis supplement can only be provided for the month that you're making the request. So for instance, not a future month. You can't make a claim for one that you're going to be encountering a future crisis and therefore you need the supplement now. You also couldn't make a request, saying that you need a crisis supplement. You can't request money for the future, essentially, is I believe what that regulation is saying. So yeah, just a takeaway here that I learned personally was, not to take the adjudicator's interpretation of the legislation at face value, and of course to take a deeper look at it. Another bit of an interesting thing in this case too is just to remember that legislation trumps policy when there's any inconsistency. I remember my supervisor telling me that during this case, when they cite the policy provision that says that a crisis supplement can't be issued for an ongoing situation, if they meet all the other eligibility criteria, that one piece of policy shouldn't necessarily be enough to deny somebody. So if we had a little bit less to rely on in this recon otherwise, we might have relied a little bit more heavily on that piece, saying, well, if somebody, I think I include a submission on that if you want to take a look at that. But I remember I got some advice from my supervisor to say, if this person meets all the other eligibility criteria, and so therefore legislation should trump policy in this case. So that little piece of policy shouldn't necessarily be enough to bar someone from accessing the supplement.
That's right. Yeah, just to reiterate, right, that policy is the ministry's interpretation of legislation and is not legislation itself. And so we always want to look at the act and the regulation for what the criteria are. In the welfare context, there are a few situations where the policy, I think, is more generous, arguably, than the legislation. So it's always important to look at both. But there has been a comment. I think that your point that, timing a request for a crisis supplement is I guess we can say it's an art, not a science, that there's options for how to reframe events that have happened to try and meet the legislative requirement for the crisis supplement, and that sometimes the ministry will choose to frame the crisis in one way when it's certainly open to the client and their advocate to frame it in another. And we've got a comment in the chat that someone's been successful arguing that another expense sopping up the money was unexpected. Something like, oh, well, I had a prescription that, I was unexpectedly ill and I needed a prescription or some medicine that I had to pay money for. Therefore, it was unexpected that I didn't have money for my hydro bill, for example. I think would be the argument that would be applied there.
Yeah, that's kind of the creative finessing of that timing and that I was talking about. Yeah.
Mm-hmm.
I think, that's all I have for this scenario.
Yeah, do we have any questions? Any other questions from the room and in the chat? If not, Madison, I think that you can move on to your next one just with an eye on the clock, because again, we're right on time, but also just barely. So
sure. Yeah, I can try to do this one maybe a little bit quicker. Okay, so this next one is administrative underpayment reconsideration that I took on just pretty recently. Okay, next slide. I'll go into the background. So yeah, like I said, this started out as a service request for an underpayment review. So maybe I can just get into this now. I think I have it in a later slide, but me and Allison were talking about that. It's possible that some advocates, even not even just clients, might not know that they can actually submit a service request for an underpayment review. We found out that it's not listed on My Self-Serve as one of the options when you're creating a service request on there. But for us at TAPS, clients come to us all the time saying, hey, I didn't receive assistance for these few months that I think I should have been eligible. Is there anything that we can do about that? So yeah, that would be an underpayment review request. The way that we usually do it at TAPS is just a simple letter that we fax in as a service request. And the letter can be, you can kind of think about how detailed you want it to be. Sometimes it might be strategic to leave it open, saying, can you just review this person's eligibility for this period? Here's some additional paperwork you might not have had at the time, or draw your attention to this paperwork you maybe did have at the time. And you can request a specific amount or make a claim of the amount you think that they were underpaid, or you can just leave it open saying, can you review to see if there was an admin underpayment here? So for this client, or I guess I'll get into the background in the next slide, but other things that are relevant for this one, oh, sorry, can you just go back for a second? Perfect. Other things we talk about here are the annual earnings exemption for people that are on PWD and how that can affect somebody's file once they've reached it. We also address the temporary exemption of EI benefits, and that's for people that were on PWD. I think it was on or before April 2nd of 2020. So for those people, they were able to collect EI benefits related to COVID or other types of EI benefits temporarily. We also talk about reporting obligations, and we discuss kind of the legal provisions around duty to accommodate with the ministry, and for instance, providing decisions in writing. Okay, next slide. Thanks. Okay, so brief summary of the facts in this case. So this client was a PWD client, and in July 2020, they had reached their annual earnings exemption, which I guess would have been $12,000 for that year. And so at that time, they reported that to the ministry and everything like that. They submitted their monthly report saying they had reached their annual earnings exemption. And then in August 2020, that person was then laid off from work due to COVID, due to the second wave of the pandemic. So because this client had reached their annual earnings exemption, and then in August, they had earned more than their monthly assistance rate, that actually made them income in excess until November of 2020. So during that time when they were income in excess, their file was switched over to MSO, medical services only. So just a reminder, that means that, yeah, someone's not getting their checks, but they do get to keep their medical benefits. And so I guess I could say that if that had continued, if the person had continued to earn more than their monthly assistance rate, then they would likely continue to be MSO until the next year when the new reporting cycle starts. But as you can see, yeah, that wasn't the case for this client because they were laid off from work in August 2020. So this client was a pretty ideal client. They had a pretty strong capacity for self-advocacy, and they knew their reporting obligations and everything like that. So they continued to report every month, submit those monthly reports. So when they were laid off, they submitted, I believe, an ROE that confirmed that. I believe they submitted, yeah, just their records of showing that they didn't receive any more income from employment after they were laid off. And you know how there's a little checkbox on the monthly report that says, are you seeking assistance for this upcoming month? And yet this client continued to say, yes, seeking assistance. I believe it was in, let's see, it'll say in my submission, but they did start to collect the CURB benefit. I believe it was in October. So in November 2020, so that would have been right after they submitted their October monthly report that stated that they were on the CURB benefit. They tried to determine whether they should be eligible for their benefits again, as they had not made any further earnings that year. So I believe they called the ministry and discussed this with them. And at that point, they were giving some pretty confusing information from the EAW who they were speaking to. The EAW was seemingly unaware of the temporary exemption for CURB benefits for people that were on PWD. And this EAW actually seemed to also be kind of going a little bit outside of their scope and trying to look into like EI eligibility and whether being on PWD prevents someone from being on EI, that kind of thing. So they were providing a lot of misleading and just, yeah, insufficient information to the client at that time. So because of that information, the client was very confused about their eligibility, and they were led to believe that they were to choose between being either on PWD again or being on the EI benefits, or essentially, yeah, just being on EI and waiting until their annual earnings exemption started again in the new year. So obviously this client was pretty confused based on some confusing information from the ministry. And this information from the ministry is actually documented, which is kind of rare because most of that correspondence happens over the phone, I would say. But in this case, my client and the EAW were messaging on my self-serve. So we actually have like the written record of that correspondence, which you can find on SCED. And it's, yeah, as you can see, it's like pretty confusing. So kind of helpful to have that. But yeah, as a result of this, the client basically just accepted that they wouldn't be eligible until their annual earnings exemption restarted in March of 2020. So the client went without PWD until that time. And then in March 2021, previously I meant March 2021. In March 2021, they came to us and we submitted a service request for the underpayment review. And yeah, that was denied. So next slide. So the reasons that they denied it was because of this one regulation. They said that this is the regulation here. I guess I won't totally read it, but basically they're saying that, yeah, a family unit is not eligible for any assistance prior to the calendar month in which the assistance is requested. So they used this regulation to try to say that because essentially the client in November of 2020, when they were trying to determine their eligibility, because essentially at that time they just accepted that they weren't eligible, the ministry is trying to say that they actually requested to go without assistance at that time until March 2021. So obviously that seems, seems pretty unjust in this circumstance, because I would say that, it's not that the client didn't request the assistance, it's that they more accurately just reluctantly agreed to wait because they thought that they had no other choice. Maybe next slide here. So I definitely felt confident about taking this to reconsideration. Although I guess I hadn't seen that before, where they do have the written correspondence, as I was saying. I guess that would be the downside of having this on written record, but you can see where my client says essentially, okay, well, I guess I'll have to wait then till March 2021. So I was thinking, shoot, well, I don't know, are we hooped in that case? But no, after looking closer at the case, I realized that, that reluctant agreement to wait until March 2021 was based on some pretty clear misinformation from the ministry in regards to her eligibility. So for the reconsideration, I guess kind of like my last one, I usually start by just restating and expanding upon how I think they're eligible for the underpayment in this case. So essentially, I went through the timeline and I just explained that once she was no longer income in excess in November of 2020, and she wasn't earning anything, the only income they were getting was from the CURB benefit. And because that CURB was temporarily exempt for people that are on PWD prior to April 2nd of 2020, the CURB benefit shouldn't have precluded her from also accessing her PWD benefits. So we requested the underpayment from November until March 2021. And then we refuted that denial reason that I was just explaining in the last slide. Well, yeah, again, we said wasn't a request to go without assistance, more of a reluctant acceptance. But we also relied on this client being, like I said, having a pretty good capacity. They were doing their monthly reports each month. So in October, November, December, January, February, all those months that they weren't getting the assistance, they were still doing their monthly reports. And thankfully, they were checking on that little box saying, I'm still in need of assistance. So we said, in fact, they were requesting assistance each month. And at that time, during those requests being processed, that should have been seen to in real time. Also, the ministry didn't issue a written decision in November 2020 when this client was having that correspondence with the ministry about their eligibility. The ministry decided they did open a service request at that time to reestablish this client's benefits, but they ended up changing it to withdrawn because the client reluctantly agreed to wait until March 2020 or 2021 because they didn't think that they were eligible. And at that time, the ministry could have had an opportunity to send a letter, some sort of formal, maybe not a decision, I suppose, since they decided for it to be withdrawn and not denied, but they could have received some more formal correspondence around that, which I think would have allowed my client to look a little closer at it, maybe bring it to an advocate at that stage, and see if that could be reconsidered or reopened. Okay, next slide, please. Yeah, so ultimately we were successful with the reconsideration. Lessons learned, what was challenging. So again, I guess that interpretation of the legislation, because of that one regulation they based their decision on. Again, as a newer advocate, I might have been reluctant to refute that, or maybe at least just a little bit apprehensive. But no, I realized that this person was, I think, was clearly misled into withdrawing their application for assistance. So I felt good about arguing that. Other than, oh yeah, I suppose I already spoke a little bit about, oh, sorry, it seems like I'm getting. So yeah, I already spoke about it being possible for advocates and clients to just request an underpayment review at any time that they think they might have been wrongfully withheld benefits. Other than that, this case, I think, was just kind of an interesting perfect storm of a lot of different elements. So the annual earnings exemption, exhaustion, income in excess, the interaction between EI and PWD during this period of temporary exemption. I suppose we're not sure if that'll continue to be a factor going forward. But anyways, we kind of just thought it was an interesting case, kind of bridging together a lot of those policy points. And then, yeah, as for the duty to accommodate piece, I think my client was pretty much the ideal client in the way that they, honestly, even pretty surprisingly, were able to continue to submit their monthly reports and continue to submit all the documents they needed to prove their eligibility during the time that was happening. So I could pretty easily rely on those things, saying, hey, this client produced all the necessary information by all the right timelines in order for these benefits to be reestablished. But I would say that more commonly cases I get with maybe underpayments, clients maybe aren't doing that so much because they don't understand their obligations, or if they've been misled to believe that they're not eligible, then why would they still be, jumping through all these hoops to provide documents, that sort of thing, I would say is more common. And I would say if that were the case in this situation, I probably still would have taken on the recon, because the ministry, they have discretion to provide assistance for a period of time during which payments were withheld, if they are now finding that the client could have been eligible for those benefits. So I would say that, yeah, I probably would have taken on cases that were maybe a bit less of a slam dunk as this one was. But also, yeah, we did include some submissions saying that the ministry, they do have a proactive duty to accommodate their clients. So not just a reactive duty when someone makes an accommodation request, but the ministry should be proactively assessing clients' needs and determining if they would like their decisions in writing, or what kind of communication is best for them to preserve the client's right to reconsideration. So I relied on that, and it was cited in the decision, saying that, they found that it was unfortunate that the client wasn't given a written decision at the time that they could have been able to reconsider at that time. But yeah, so I think that was probably helpful to include as well. Yeah, and I think that's everything I have for this one.
Thanks, Madison. I'm just looking at the chat to see if there's any questions there. One thing I've noticed over the years is that TAPS does do quite a volume of administrative underpayment requests with quite some success. And one of the reasons I wanted to have the case included was simply to remind folks that where there have been ministry errors in applying the legislation, that is certainly an option. And I think that in practice, when administrative underpayment requests are submitted, the ministry often takes the position that they only have the authority to go back 12 months. Is that what you found as well?
I'm not sure.
Another option, I think it's 12 months. There's a period of time that they cite. I think it's a year. But also remember that if you have an administrative underpayment that maybe reaches further back in time, another option is to make a complaint to the ombudsperson, because administrative underpayments are almost inevitably procedurally unfair because it's as a result of an error by the ministry, and that there's no limit on the length of time that the ombudsperson can make recommendations to the ministry about. I've got a comment in the chat. Excellent example of the ministry's duty to accommodate. Yeah. I was also thinking about the interaction. I thought it was interesting to see this case compared to Andrew's case, where the client had applied for a refund, a reimbursement of monies. And I was thinking, oh, well, could Andrew's case client instead have asked for an administrative underpayment? And no. So the difference between the two is that in Andrew's case, the ministry had administered the legislation, strictly speaking, correctly, because she had in fact received CPP-D in those months, even though she later had to repay them. So, but at the time the decision was made. And so I guess that's the main distinction between the two: administrative underpayment, where there's an error by the ministry, and now the new trick we have in our toolbox, which is application for reimbursement or refund, where there's a procedural unfairness and unfairness in the outcome, where there has been an alleged an overpayment in relation to the benefits from the third party source that the client collected and that the ministry then deducted. So I'm just keeping my eye on the chat. I'm not seeing any questions, and it is 11 o'clock right on the dot. I've got some thank yous coming in, and I just want to say thank you to all of the presenters. Thank you so much for participating and agreeing to go over your cases. I know that you all are extremely busy with your own work, and this is something extra that you did off the side of your desks. So I really appreciate it. And I think that between the presentations and the materials, the submissions and decisions that you'll find in SCED, with the exception of Arnie's case. Arnie's was an initial application, so there aren't materials in SCED for Arnie's case, but there are submissions and decisions for all of the other cases that we discussed here today. So make a point of downloading those, saving them, and hopefully they'll be very helpful for you in your own work.